The prosecutor's comments are in contrast to efforts underway in South Africa to explore legal options that might allow it to sidestep the arrest warrant. This was the Director General in the Department of International Relations before Parliament's Portfolio Committee on International Relations on Wednesday.
This is the first third-party state where a warrant of arrest has been issued, where that warrant of arrest does not come through the Security Council. I think it's important to emphasize that. If you're a state party, you automatically waive immunity. If you are not a state party and you are presented to the ICC through the Security Council, immunity is waived. But if you are not a state party and it doesn't come through the Security Council, Article 98 of the Rome Statute requires a waiver from that country. So we are looking at all of these matters, which includes our obligations both to the ICC, but also obligations towards international customary law, which Article 98 looks at. Our Act domesticates most of the elements of the Rome Statute, but we have not domesticated Article 98.
A third-party state refers to a country that is not a contracting state to the Rome Statute, as in the case of Russia. Article 98 deals with the question of cooperation with respect to waivers of immunity and consent to surrender, stating that the court may not proceed with a request for surrender, for example, to South Africa, unless the court can first obtain the cooperation of that third state for the waiver of immunity, in this case Russia, which Dangor concedes is subject to various legal interpretations and issues that the Inter-Ministerial Committee is grappling with. Legal experts argue that Article 98 limits only the capacity of the court and does not grant states parties a veto to ignore a request for surrender. Additionally, Article 27 speaks to the irrelevance of official capacity, specifically that immunities or special procedural rules which may attach to the official capacity of a person, whether under national or international law, shall not bar the court from exercising its jurisdiction over such a person. The ICC prosecutor, speaking on an official visit to Canada in early May, pressed on South Africa's role regarding the issued warrant of arrest.
South Africa, first, is a respected state party. It wasn't dragged kicking and screaming to the International Criminal Court. I have phenomenal respect for South Africa for many reasons. Not only is it a great country with so much potential, but it is, for me, it's the country of Nelson Mandela. And the greatness of heart that he showed with the terrible crime of apartheid, I don't think South Africa needs lessons from anybody. And I think Canada is seeking to act consistently around the world. Other countries should do the same. And I have every confidence that South Africa, realizing what it is like to suffer, what it is like when rights are taken away, what it is like to be subjugated, as a matter of their sovereign independent will and as state parties that are committed to the rule of law.
He went on explaining that South Africa owned the law as much as Canada, the UK and other states parties do.
The law is equally owned by all of humanity, and I think South Africa, God willing, will, as an exercise of sovereign will, out of the values that it holds dear, pursuant to its constitution that is fantastically drafted in the shadow of apartheid, they will decide that they own the law and they want to act on the law for their own people and for the world they want to bequeath to their children as well.
For South Africa, the adage, caught between a rock and a hard place, has never rung more true. Sherwin Bryce-Pease, SABC News, New York.